want to do three things. First, I want to say a bit more about how I got my clerkship in the first place. Second, I have one good story about the clerkship that isn't on the website. And third, I want to try to place Justice Ginsburg into larger context. So first, I originally had no interest in clerking when I was in law school. I viewed a clerkship as a way to prolong adolescence. And as one of the oldest students in my class, I had managed to do that just fine on my own. But several of my professors encouraged me with varying levels, indeed increasing levels of persistence, that I throw my hat into the ring. So I came up with a plan. I would apply to a handful of judges with whom I had no chance. The professors would write their recommendation letters and nothing would happen, so I would get on with my life. Things didn't quite go according to the plan. I did everything wrong in applying to Justice Ginsburg. I mean, everything. And it started right away. Based on incomplete information, I assumed that she was already on the DC circuit when I sent in my application. Sometime later, I got a letter not from Washington, but from Columbia Law School, where she was still on the faculty. It was a nice letter explaining that her nomination had only recently gone to the Senate, but she also asked me for more information, so I sent that. Then she asked me for more information, so I sent that. And then she invited me to come to New York to interview at her home. That's how I came to knock on her door shortly after 9:30 in the morning on June 18th, 1980, where I was greeted by her then 15-year-old son, who said to me, "I was going to ask you why you want to clerk for an unconfirmed judge, but I can't do that. The Senate just confirmed her. She just got the phone call." So I was the first person outside of her family whom she saw. We had our conversation. She made the offer. I took it. Okay. Second, quick story from the clerkship. The clerks divided the cases that would be argued in each sitting, and we wrote bench memos on every case that was going to be argued. A few days before the argument, the judge would meet with each of us to discuss our cases. One that stands out was a libel case against the Washington Post. The case reached us on an arcane procedural issue, not on the merits, but the briefs were, to put it mildly, vitriolic. After we discussed the legal issues, the judge remarked about the harsh tone of the briefs. I offered a hypothesis. One of the plaintiffs was George Preston Marshall, Jr., whose father was the founder and longtime owner of what until recently was called the Washington Redskins. Now, the Post was represented by Williams and Connolly, whose senior partner, Edward Bennett Williams, owned the Redskins after Marshall Sr. did. Williams detested Marshall Sr., and the feeling was mutual. Williams thought that Marshall Sr. was an unreconstructed racist, and he had some basis for that. The Redskins were the last team in the National Football League to have a black player. I suggested that the terrible personal relationship between Williams and Marshall Sr. might have something to do with the tone of the briefs. The judge listened attentively and then, in all seriousness, asked, "What are the Redskins?" Now, of course, she had many interests outside of the law. Sports was not among them. Now, some more general points. Ruth Bader Ginsburg was a figure of national stature when she became a judge. She would have been an important person historically even if she never sat on the Supreme Court. In that sense, she was similar to Thurgood Marshall, Oliver Wendell Holmes, and William Howard Taft, all of whom had distinguished careers before their appointments to the court. Ginsburg was a leading scholar who wrote extensively on procedure and jurisdiction, as well as constitutional law. More important, she led a litigation campaign that resulted in a fundamental transformation in the law of gender discrimination. When she began those efforts, the court in its entire history had never struck down a gender-based law as unconstitutional, but it had upheld quite a few, including some where the court clearly refused to take the claims seriously. Then Professor Ginsburg changed all that in cases that she argued and in others on which she advised. She was a brilliant lawyer and a shrewd strategist, as shown by her enthusiasm for using male plaintiffs as part of the campaign for gender equality. And she brought that strategic sense to the Supreme Court, especially when she became the most senior member of the liberal wing in 2010. She helped to keep the group unified in some high-profile cases. And sometimes that meant not writing separately, even when there was plenty to say. Take, for instance, Obergefell against Hodges, the same-sex marriage decision. That was a 5-4 ruling in which Justice Kennedy wrote for the court. His opinion was unconventional in many ways, and almost certainly the other justices in the majority would have written it differently. But none of those justices wrote anything. I don't have any inside information, but I strongly suspect that Justice Ginsburg had something to do with that. She would have hesitated to write separately so as not to undermine the force of the court's ruling, and I further suspect that one way or another, she conveyed her views to Justice Breyer, Justice Sotomayor, and Justice Kagan. Similarly, last term in Bostock against Clayton County, which held that employment discrimination based on sexual orientation violates Title VII, Justice Gorsuch wrote for a 6-3 court, relying exclusively on textualism to interpret the statute. There are other approaches to statutory interpretation, but none of the liberal justices said anything about those alternatives. And I see the strategic hand of Justice Ginsburg there too. During her entire time on the Supreme Court, Justice Ginsburg was in the minority. Most of the justices were appointed by Republican presidents. Indeed, when she was confirmed in 1993, she was the first Democratic appointee in 26 years. In the meantime, there were 11 consecutive Republican appointees. Now, she wrote at least her share of opinions for the court, most notably United States against Virginia, which struck down the male-only admission policy of the Virginia Military Institute. But she will probably be best remembered for her dissents. One notable example is Ledbetter against Goodyear Tire and Rubber, which rejected a claim of gender-based pay discrimination as untimely. Justice Ginsburg strongly disagreed with the majority's what she called parsimonious reading of Title VII, and explained in detail why the claim not only was timely, but in her view, meritorious. She concluded by noting that it would be up to Congress to amend the statute to make clear that claims like Ledbetter's were timely. And that was, in fact, one of the first pieces of legislation that Congress passed in 2009. Her dissent in Shelby County against Holder, which gutted a central part of the Voting Rights Act, challenged Chief Justice Roberts' majority opinion in virtually every particular. As she put it, throwing out that provision when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. In this respect, Justice Ginsburg's legacy might be like Justice Holmes's, more famous for her dissents, even though she wrote a good number of opinions for the court. And here I want to conclude by returning to my earlier observation about her national stature, even before she went on the bench. Justice Ginsburg was confirmed unanimously for her seat on the DC Circuit and virtually unanimously for her seat on the Supreme Court. That would never happen today. The parties are much more polarized than they have been in the past, and ideological reliability is the main, indeed, for many people, the only qualification for a place on the bench. These days, the field of acceptable candidates is defined in terms of track record, which for Supreme Court seats means prior judicial service. Today, the combination of polarized parties and the ability of a simple majority of senators to confirm a nominee aggravates our larger political crisis. Ruth Bader Ginsburg might be the last widely recognized figure of national stature to be appointed to the Supreme Court for years to come. Indeed, our current political polarization raises the question whether there can be general recognition of figures of national stature. I hope I am wrong about that. Still, tonight, I am deeply saddened not only by the death of my judge, but also by the grim prognosis for the Supreme Court as an institution and my country as a whole.
Okay, well, hopefully we can have more uplifting remarks later on. Who is going next? Okay, I will decide. Jonathan Adler.
Okay, well, it's a pleasure to be here today. My remarks won't be anywhere as interesting or illuminating as Jonathan's were, but I wanted to say a little bit about some aspects of Justice Ginsburg's career and time on the courts that were perhaps less known, and including some of her important opinions in areas that she might not be known for. I agree very much with Jonathan that she is on the Supreme Court usually remembered for her dissents, and particularly in high-profile cases, as the senior most liberal justice for much of her time on the court, or much of the Roberts Court, I should say. She had the decision the authority to decide who would write the lead dissent in many cases that divided the court along ideological lines, and took that opportunity, particularly in some of the cases that Jonathan noted. Now, some of the things I think are important to note about Justice Ginsburg. Well, first, she was a former academic, which for us, I think, is something was always important to highlight. We're always in favor of academics being on the bench. She taught both at Rutgers and at Columbia Law School, the latter being where she graduated from law school. As I think many people know, she was one of a handful of women to attend Harvard Law School in the 1950s. But when she and her husband Marty decided they were moving to New York, Harvard would not allow her to continue to be enrolled if she was not going to be taking classes in Cambridge. So she transferred to Columbia and ended up graduating from Columbia instead. And the story is that when Harvard later wanted to offer her a JD, she said no thank you, that they had their chance, but was willing to let them give her an honorary degree. After her close to 2 decades of teaching, as Jonathan mentioned, she was on the DC Circuit. And a bunch of things are interesting about her time on the DC Circuit. One was the close friendships she struck up with both Justice Scalia, who joined the DC Circuit shortly after she did, and also with Justice Thomas, who up until this past week, almost all of Justice Thomas's career was spent with Justice Ginsburg as a colleague, given the relatively short time between his elevation to the Supreme Court and hers. And I'll say a little bit more about her relationship with Justice Scalia in a moment. On the DC Circuit, this is a court that mostly focuses on administrative law questions. This was not the area of law that Justice Ginsburg herself focused on. She was actually a civil procedure scholar, and in fact, also a bit of a comparativist. After law school, she did a project looking at the civil procedure of Sweden, and apparently post-law school taught herself Swedish so that she could do this. If you look at a lot of the opinions that she wrote, a lot of the areas of law that she focused on, apart from the high-profile constitutional cases, you can see her focus and interest in civil procedure and her interest in parsing texts like the rules. But during her time on the DC Circuit, she actually had a role in some important cases. One thing that a lot of people forget is that in a case called In Re Sealed Case, which was the lower court opinion in what became Morrison versus Olson, she wrote the dissent to Judge Silberman's opinion holding that the Independent Counsel Act was unconstitutional, a dissent that was subsequently vindicated in Morrison versus Olson in a 7-1 opinion written by Chief Justice Rehnquist. Her whole dissent is worth a read. I think it's worth quoting from the closing paragraph from that dissent. The Ethics in Government Act is a carefully considered congressional journey into the sometimes arcane realm of the separation of powers doctrine, more particularly into areas the framers left undefined. The act is designed to prevent Congress's own appropriation of the functions it insulates from executive supervision, and it implements a fundamental control essential to our Constitution's doctrine of separated powers. The control of mutual checks, Constitution's doctrine of separated powers, the control of mutual checks. It is a measure faithful to the 18th century blueprint, yet fitting for our time. I find the Ethics Act constitutional and would affirm the judgments of the district court. And I think on Justice Ginsburg's passing, I think it's worth highlighting this dissent, because I think this dissent is a very clear articulation of a particular view of separation of powers, not only the one that was ultimately vindicated by the court, but one that stands in contrast to the conception of separation of powers associated with Justice Scalia's Morrison versus Olson dissent, which is regularly quoted, taught, and pointed to. And particularly when her opinion is placed side by side with Chief Justice Rehnquist's Morrison decision, I think hers is the clearer, better articulated account of an alternative view of separation of powers to that presented by her good friend, Justice Scalia. And it would certainly be fitting to her legacy if we recovered this dissent and thought of it as a good articulation of this alternative view. Another case she was involved in where the outcome, at least for her point of view, was not as positive, and where by historical accident she has arguably been associated with what we may think of as a DC Circuit mistake, is that she was assigned the lower court opinion in Chevron versus NRDC. So she wrote the opinion in the DC Circuit that invalidated the Reagan administration's effort to reinterpret the Clean Air Act and adopt what was called a bubble policy, which was designed to make it easier for regulated firms to comply with the Clean Air Act's requirements by giving them more flexibility in firm operations and making it easier to avoid the obligation to install additional pollution control equipment. Under a range of several DC Circuit opinions, this sort of policy was only allowed in parts of the country that were obligated to maintain existing levels of air quality, as opposed to those parts of the countries that were obligated to reduce existing levels of air pollution. And on that basis, Justice Ginsburg wrote the opinion striking down the Reagan administration policy. This opinion was, in many respects, also vintage Ginsburg. It was not a textual exegesis so much as it was focused on the understanding of the Clean Air Act as it had been applied and implemented, as well as how it had been interpreted in the courts. She was unimpressed by the Reagan administration's fairly cursory explanation of why they wanted to change the policy, and wrote what was a fairly straightforward opinion explaining why, given that there was no textual command for this approach, no obligation in the statute to be found in the legislative history, which in her words was at best contradictory, the Reagan administration policy should be rejected. Now, as I think folks may be aware, the Chevron doctrine is something that's controversial today. It was adopted by the Supreme Court in the unanimous opinion overturning Justice Ginsburg's lower court opinion. What's perhaps ironic about the fact that her opinion was the one that was reversed is that of the various DC Circuit opinions adopting this approach to the Clean Air Act, hers was by far the most restrained, the least bombastic, and the least policy-oriented in its exegesis. If you think about some of the other DC Circuit judges that she spent time with that were also writing opinions in this period, judges like Skelly Wright, these were judges that were known for being very aggressive in their statutory interpretations, adopting broad purposivist interpretations that forced agencies to do things they didn't want to do. And one might have thought that those would have been the opinions that the Supreme Court singled out to reverse. But for whatever reason, it was her more modest, more restrained opinion that the Supreme Court opted to review. And so for whatever reason, she is the one who is associated with the DC Circuit's lower court error. And is it also doubly ironic because today it is not liberal justices that are raising questions about Chevron doctrine, but rather justices on the right. On the Supreme Court, as I already noted, she wrote lots of opinions related to civil procedure and statutory interpretation. I wanted to highlight just a couple cases that are worth remembering. One is she wrote what is one of the most important standing decisions, particularly in the area of environmental citizen suits, a case called Friends of the Earth versus Laidlaw Environmental Services. And here again, her opinion is the counterpoint to the relevant Scalia opinion. Her opinion in Friends of the Earth versus Laidlaw Environmental Services put the brakes on Justice Scalia's effort to redraw the law of standing to make it more difficult for citizen suits and activist groups to engage in litigation. She wrote an opinion for 7 justices. It was not a 5-4 decision. Justice Scalia lost soundly in that case. And the case also was extremely important for cleaning up and expounding upon the law of mootness, especially as it applies to the enforcement of environmental statutes. It's a particularly important environmental decision and one that I think is often overlooked that she wrote. One other environmental decision I wanted to note, just because there are some fun facts about it, is that she wrote the opinion for the court in a 6-2 decision in EPA versus EME Homer City Generation. It involved interstate air pollution. The fun fact about this case is that this is the only case in which the Supreme Court overturned a decision by then Judge Brett Kavanaugh on the DC Circuit. So the one time then Judge Kavanaugh was reversed wasn't an opinion that was written by Justice Ginsburg, and perhaps that is fitting given what happened to her in the Chevron case. As Jonathan already noted, during much of the past decade, she was the senior most liberal justice, and that certainly meant she was writing fewer majorities and far more dissents and deciding who was going to write dissents. But the last thing I just wanted to mention very briefly is to comment a little bit on her friendship with Justice Scalia in particular, a friendship that was very close over their time on both the DC Circuit and the Supreme Court, and a friendship that withstood their quite stark disagreements on matters of statutory interpretation, the Constitution, and much else. She wrote the foreword to the first book of Scalia's writings that was published after his death. He wrote the mini profile of her in Time Magazine's 2015 issue dedicated to American icons. In that issue, he wrote that having had the good fortune to serve beside her on both courts, I can attest that her opinions are always thoroughly considered, always carefully crafted, and almost always correct, which is to say we sometimes disagree. That much is apparent for all to see. What only her colleagues know is that her suggestions improve the opinions the rest of us write, and that she is a source of collegiality and good judgment in all our work. In fact, it is known that at times on both the DC Circuit and the Supreme Court, she would occasionally line edit the opinions of her colleagues prior to publication. Another comment that Scalia made about Justice Ginsburg at a joint appearance some years ago about their friendship was, "What's not to like, except her views on the law? We agree on a whole lot of stuff," he added. "Ruth is really bad only on the knee-jerk stuff." And of course, she said similar things about him. In an interview with Joan Biskupik, she said, Nino, in my view, sometimes does go overboard. It would be better if he dropped things like, this opinion is not to be taken seriously. He might have been more influential here if he did not do that. I love him, but sometimes I'd like to strangle him. They were great friends, and I think that in a time like ours, where the partisan differences are as strong and as deep as they are, in a time when it seems that people that disagree have such a hard time getting along, I think that the example she set for having love and admiration for someone with whom she disagreed, but with whom she could still work, is a model that is worth following. And I thought that was worth mentioning in our program today. I will, at this point, turn it over to whoever Professor Hoffman says is up next.
Thank you so much, Jonathan. I do have one question. Could you specify the name of the case where you discussed the first dissent? Was that Olson?
So the Supreme Court case is Morrison versus Olson. The lower court opinion where she wrote her dissent is just titled "In Re Sealed Case," and that's because sometimes when certain sorts of cases come up in the lower courts, they are initially sealed because they have to be, looked at for confidential information and the like. And so in the DC Circuit, there are a whole lot of cases with that title, but I will, in the Q&A box, I'll put the citation in the box for people that want to look it up.
Thank you so much. Jesse, you're next.
Thank you, Sharona. Well, what I want to do is just take a little bit of time to talk about one particular area of law where Justice Ginsburg had an enormous influence, although she had an enormous influence in so many areas and divergent areas of law, as the first two speakers' remarks have demonstrated. I want to focus on reproductive rights, and particularly sort of give some context around Justice Ginsburg's jurisprudence in that area and how her philosophy contributed to where we are today in terms of reproductive rights, and what the future briefly, sort of a few remarks about what the future looks like without Justice Ginsburg on the court in this particular area. So of course, it's already in the news. Everybody's thinking about Roe v. Wade and what the future is for Roe v. Wade. Well, in 1973, when Roe was decided, Justice Ginsburg was then an attorney litigating some of the early gender discrimination cases that my colleague Jonathan Enton mentioned in his remarks. So Reed versus Reed was in 1971. Frontiero v. Richardson was in 1973, decided a matter of days before Roe. And Weinberger v. Wiesenfeld was in 1975. Of course, Justice Ginsburg was not appointed to the Supreme Court. She did her stint on the DC Circuit and then was appointed to the Supreme Court in 1993. That was the year after the landmark case, Planned Parenthood v. Casey, which is still the case that sets out the legal standard by which abortion restrictions are judged, the constitutionality of abortion restrictions are judged today. So in between that time, or during the 1980s, Justice Ginsburg, who was then Judge Ginsburg, put forward a very influential view that Roe should have been decided on equality grounds rather than on the right to privacy. She suggested, among other things, that this basis for recognizing a right to terminate a pregnancy, gender equality, would have been less controversial, and it would have been more reflective of what abortion restrictions are really all about. The real essence of abortion restrictions is that they compromise women's equal citizenship. Of course, this was the world that she came from, right? The world of sort of litigating for gender equality. But at the same time, that's the entire doctrine of gender equality was very separate at the time from the doctrine of privacy, out of which the right to abortion grew. I don't know whether in the end we would have ended up anywhere different than where we are today in terms of abortion rights if the court had pursued the path that Justice Ginsburg suggested in terms of seeing the abortion right as an aspect of equality rather than privacy. But it's interesting to note that Casey, the landmark case decided in 1992, clearly reflects this greater equality focus. And actually, much of the Supreme Court's abortion rights jurisprudence since that time is more cognizant of the sort of equality concerns that Justice Ginsburg raised. In abortion rights cases, Justice Ginsburg was always a staunch, sort of reliable pro-choice vote. But interestingly, given the long shadow that she casts over this issue, she did not author any of the majority opinions in any of the major abortion rights cases when she was on the Supreme Court. So she had some very important and influential concurrences and dissents, but even when she was voting with the majority, she did not generally write the opinion. I think what really stands out about some of Justice Ginsburg's opinions in the abortion rights area is kind of how clear-eyed they were and how clearly she sort of cuts through the nonsense and sees right to the heart of what is going on in the case. For example, in a 2007 case, Gonzalez v. Carhart, the majority voted to uphold a ban on a particular method of abortion on the ground that it was inhumane, essentially, and that women, one aspect of the court's rationale was that women would be upset and suffer regret if they learned afterwards that the abortion had been performed in this inhumane way. This was the court's decision, even though the court acknowledged that the alternative procedure that women would have to undergo now could bring greater safety risks for some women. Justice Ginsburg dissented in this case and said of the majority's opinion, quote, "Because of women's fragile emotional state and because of the, quote, bond of love the mother has for her child," that bond of love language is from the majority's opinion, "the court worries doctors may withhold information about the nature of the procedure. The solution the court approves then is not to require doctors to inform women accurately and adequately of the different procedures and their attendant risks. Instead, the court deprives women of the right to make an autonomous choice, even at the expense of their safety." And then she went on to say, "This way of thinking reflects ancient notions about women's place in the family and under the Constitution, ideas that have long since been discredited." And then she goes on to cite actually some of the cases that, again, John Enton had mentioned, some of the early cases, paternalistic cases upholding discriminatory laws against women, and then later cases rejecting that line of thinking, that paternalistic line of thinking. She ends by saying, or ends this passage by saying, "Though today's majority may regard women's feelings on the matter as self-evident, this court has repeatedly confirmed that the destiny of the woman must be shaped on her own conception of her spiritual imperatives and her place in society." So I think it's, one example of how this sort of conception of reproductive rights and abortion rights under an equality framework really worked their way into not just Justice Ginsburg's jurisprudence on abortion rights, but also into the sort of broader understanding in Casey and subsequent cases as well. Similarly, again, another sort of clear-eyed concurrence actually in the 2016 case, Whole Woman's Health, v. Hellerstedt. In that case, the court struck down some restrictions on abortion clinics that would shut down in Texas 3/4 of the state's abortion clinics and bring little to no medical or safety benefit to patients. So Justice Ginsburg was voting with the majority, but made a point of writing a separate brief concurrence just to highlight essentially the highly pretextual nature of the abortion restrictions that were claimed to be for women's benefit, but in fact were actually likely to subject women to greater health risks because they would have the effect of shutting down clinics, leaving women without safe legal options for seeking abortions. Finally, she had several opinions as well, or she had some notable opinions as well in the context of birth control and access to birth control and religious exemptions from birth control, the birth control mandate under the Affordable Care Act, including in the Hobby Lobby case, as well as in the case of Little Sisters of the Poor, just from this past term, decided on July 8th. Little Sisters of the Poor v. Pennsylvania. She talked about Congress's determination in the Affordable Care Act to afford women employees equal access to preventive services, thereby advancing public health and welfare and women's well-being. Again, tying contraceptive access to gender equality in dissenting from the majority's decision to uphold, at least on the certain bases, to uphold the broad religious exemption that the Trump administration had created for employers. Okay, so 2 minutes just to say what comes next here. I think in terms of reproductive rights, the elephant in the room is certainly the future of Roe v. Wade. If, as appears likely, a new justice is appointed who is on the conservative, sort of the most conservative end of the spectrum on the Supreme Court, I think there will be likely 3 reliable votes on the Supreme Court to overturn Roe v. Wade. There are 3 reliable votes, the 3 remaining liberal justices, to keep Roe v. Wade. I think the justices who would vote to overturn it are Thomas, Alito, and whoever is coming next. So there are 2 who I might say are in the middle, Justice Kavanaugh and Chief Justice Roberts, but I would not say that those are in the middle in the sense you might traditionally think of on this issue. They are sort of the median justices on this issue, and really it's probably Kavanaugh who is the median justice on the issue. I somehow left Justice Gorsuch just completely off the court. I must have just repressed him in my mind, but he's the 4th vote, sorry, on the conservative wing to overrule Roe. I don't know why I left him off. So we have, I think, Roberts and Kavanaugh on the as the median justices on the court, right in the middle, the 2, and really it's probably Kavanaugh. Chief Justice Roberts wrote a very lukewarm defense of stare decisis in the Supreme Court case of June Medical Services v. Russo this past term, and then also Justice Kavanaugh has been playing his cards very close to the chest and not really giving us an indication of where he's going, but he has been on the record in the past as being not a big fan of Roe v. Wade. So that's where we are at the moment, and I will just finally note that there are some cases making their way up through the Supreme Court right now that could potentially be the case where the court considers overturning Roe v. Wade. There is a 15-week abortion ban out of Mississippi where there is a cert petition currently pending, for example, as well as probably a dozen other cases sitting in the courts of appeals right now. And the Supreme Court could decide to hear any one of them as soon as this coming term. Okay, so I'm gonna stop there and turn it over, I guess, to Sharona and Ray. Thanks.
Okay, well, just a reminder, please type your questions into the Q&A box. The icon is at the bottom of your screen. And we will now hear from Professor Ray Koo.
All right, thank you, Sharona. And I'm trying to do my best to add to all the wonderful comments from my colleagues. And I'll proceed in two parts. The first is just going to be kind of things you may not know about Justice Ginsburg in terms of her role as both a justice and as a litigator. And then my overall reflections on, I think, what we're sorely going to miss in terms of her contributions as a justice. And so first, one of the things that Sharona mentioned is kind of my interest in technology, internet law. And for those of you that follow that field, one of the most important decisions for quite some time was the decision in Eldred versus Ashcroft, which was a copyright decision in which the Supreme Court upheld Congress's decision to retroactively and proactively extend the term of copyright protection for 20 years. And Justice Ginsburg wrote the majority opinion for 7 justices. What most people don't necessarily know is, yes, Justice Ginsburg served on the faculty of Columbia Law School, and her daughter, Jane Ginsburg, also serves on that faculty and is in fact one of the world's leading experts in copyright law. And along those lines, she's not what often critics would describe as the copy left, kind of the more minimal copyright protection approach towards the law. She has been fundamentally in the camp that copyright serves a very, very valuable public purpose and should be as robust as possible. So it's fundamentally not, it wasn't very surprising when Justice Ginsburg wrote the opinion that she did in terms of recognizing the importance of copyright and its policy and its role in kind of encouraging creativity and the distribution of the work. I mean, one can only really imagine if she had struck down the Sonny Bono Copyright Term Extension Act, what the dinner conversations would have been like with her daughter afterwards. So, totally random story along these lines, just simply because most of you may not have known she wrote one of the most important copyright opinions at the end of the 20th century. The other kind of comes on, I think it was John Adler who was making the point that, she was also an academic, and many of us academics certainly love the idea that an academic would be appointed to the Supreme Court. It really doesn't happen very often, if really ever, because I want to emphasize too that, and Professor Enton really emphasized this as well as Professor Hill, that Justice Ginsburg really, in my mind, kind of is one of 2 of the justices in essentially the court's history that was a major pioneer as a litigator. So if we think of Thurgood Marshall's role in equal protection and desegregation cases, right, his strategy for the NAACP has often been considered the strategy that ended up leading to the victory in Brown versus Board of Education, ending public segregation. As Jesse pointed out, Justice Ginsburg's approach towards litigating gender discrimination cases easily fit within that mold. I mean, so many of the early gender discrimination cases weren't simply that women were being discriminated against, or that the government was relying on outdated stereotypes, but actually fundamentally based on circumstances and cases in which women actually benefited from the discrimination, right? So men were essentially penalized for the regulations and laws at issue. And her emphasis, however, was even though that was true, right? So even though the laws on their face seemingly benefited women, they were still fundamentally denying women equal protection because ultimately their theories were based on a view of women as essentially inferior to men in reality and in the law, right? And so an example of, you know, what I think was in the end a very successful long-term strategy on changing the equal protection doctrine's view of women under the Equal Protection Clause. And before we go on then to the other element here is she tried that recently in the Arizona State Legislature versus Arizona Independent Redistricting case, a case involving gerrymandering, not one specifically aimed at partisan gerrymandering as the Commonwealth versus Rucho case ultimately became. But this was a decision before Rucho in which she was able to get a 5-justice majority to make essentially the point that partisan gerrymandering and the practice of essentially the practice of gerrymandering itself when it was not tied to representative democracy was in fact a threat to democracy. Really, again, as a litigator and as I teach my students when thinking about constitutional cases, the best of the justices and the best attorneys are always thinking several cases ahead. And so she had potentially laid the groundwork in the Arizona case for a much firmer and perhaps a more robust view of protecting equal protection in the gerrymandering context. And you may even argue that to some extent she succeeded there as the majority of the court essentially did recognize that gerrymandering could in fact be anti-democratic. Their conclusion, however, was essentially not based on that kind of substantive conclusion or result, but on the fact that they couldn't come up with a standard for judging any remedy for partisan gerrymandering, right? So yeah, she was not only a brilliant justice, but a brilliant, strategic thinker and litigator. So I did say I wanted to kind of overall end with what I think we will miss from Justice Ginsburg's role and participation in the court. And it's really twofold, though, as you'll see, they're interconnected. And the first is essentially her fundamental belief in the inclusiveness of the Constitution. And for her, right, the inclusiveness is not a kind of liberal position, right? It is not an example of the elites and progressives in society rewriting the Constitution. She saw this as fundamentally going back to the original principles of the founding of this nation and the Constitution itself, right? So even though she would say that, yeah, when the framers wrote, "We the people of the United States," her view was they certainly couldn't have meant everybody, especially given that in her direct language, human bondage was a thing, right? And the Constitution preserved slavery. And certainly, quote, not women, whatever their color, and not even men who own no property. It was rather an elite group. But her current approach was to essentially, and again, this is why I liked her relationship with Justice Marshall, where she said she liked his position because he didn't celebrate the original Constitution, but he celebrated what the Constitution had become. And in her view, she saw, this is a quote from her specifically, "I see my advocacy as part of an effort to make the equality principle everything the founders would have wanted it to be if they weren't held back by the society in which they lived, and particularly the shame of slavery." So as we then kind of see through many of her most influential opinions, the importance of diversity and the importance of representation of different views was a fundamental part of her jurisprudence, right? And of course, you can't deny or overlook the circumstances that, as my colleagues have pointed out, she herself was fundamentally a minority when she went to law school and she began her legal career. And so for her, the kind of treatment of minorities at the elite level of education, at the elite levels of the legal profession as a justice, a judge and a justice, was a very personal experience for her. And in fact, Eugene Scalia, Justice Scalia's son, in a recent essay, wrote that perhaps one of the reasons that he and his father and Justice Ginsburg bonded was the fact they both came essentially from more minority and therefore outside groups in the kind of elite legal system, right? She coming from the Jewish tradition and Justice Scalia being an Italian Catholic, right? So they bonded in that sense of recognizing like the outsider status that they had in the more kind of elite circles of American law. And so along those lines, right, well, we're thinking of her other prominent cases, right? United States versus Virginia has been raised, right? And this was, of course, the conclusion that the Supreme Court reached that VMI, the Virginia Military Institute, had to, in fact, allow women to apply to the university, and it could not maintain its all-male status. And again, it was fundamentally based upon the idea that if we want elite leaders who are trained in an adversarial method of education and who will then either go on to become leaders in the military or leaders in society, there's absolutely no reason women should be excluded from that. And her recognition, look, that there are plenty of men who would not desire that is the same as the fact that there are plenty of women who may not desire that. Any real differences between men and women under those circumstances were essentially assumptions based on stereotypes and more limited traditional understandings of women and their role in society. And in that, one of her lines from that case is one that I particularly enjoy, which is that inherent differences, she would go, between men and women, we have come to appreciate remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on an individual's opportunity. Right, and you know, it wasn't just gender equality that she kind of championed inclusiveness for. She wrote one of the concurring opinions in Grutter versus Bollinger, in which the Supreme Court upheld the affirmative action program at the University of Michigan School of Law. And one of the most important elements, and so this goes to both the inclusiveness, but the other element I find fundamentally important in Justice Ginsburg's work, the importance of facts. So I forgot which one of you raised earlier the idea that she may be like Justice Holmes, may be more remembered by her dissents. But Justice Holmes is also quite famous for his view about experience and facts in understanding the Constitution and common law in general, right? And so Holmes once said that a page of history is worth a volume of logic, right? And those of us who spend way too much time on constitutional law may recognize that one of the fundamental disagreements between what you might describe as the conservative branch or the progressive or liberal branch is essentially over questions about facts, right? So is it a fact that there are women who would be capable of participating in an adversarial method of education? Is systemic discrimination against African Americans in particular, but other disenfranchised or minority groups, a reality for the purposes of inclusion and representation in graduate school programs and undergraduate programs? In Shelby County versus Holder, as I believe Jonathan Adler mentioned, right? So we're talking about the Voting Rights Act. is the history and societal discrimination and treatment of African Americans with respect to voting still discriminatory in some cases, in some states, justifying continued federal oversight of those state elections, right? And again, the idea that maybe we have moved past discrimination was an important element in her view, right? But she was never willing to say that we are there yet, right? That there is too much evidence that both in underrepresentation of potential originally underrepresented groups in education, and then the treatment of African Americans in voting and attempts to suppress African American votes were certainly realities that Congress in particular, as well as state governments could and should address. And I'll leave with one other point here, and that is in that diversity and inclusion, she believed it was actually an important fundamental interest in terms of education policy. Right, so diversity and inclusion so that we, the people, actually represent all of the people wasn't simply a legal principle that was there to prevent essentially the infringement of that by states or by the federal government, but a positive value that states could in fact promote, right? So Grutter, the example that affirmative action policies, we don't need to adopt them, but they have very valuable educational societal purposes for their adoption. And I'll just leave very briefly, in a decision called Christian Legal Society versus Martinez, Justice Ginsburg wrote the opinion that said that the University of Hastings School of Law could consider and limit student groups to funding as long as they had a commitment to allowing anyone to be members of the group and serve as officers of the group. Now, while obviously there are certain groups that wouldn't want that, they would only want people to adhere to their specific viewpoints, Justice Ginsburg was very clear in saying that a university could have as its educational goal and mission the inclusion of all individuals in society, even if that's not the rule or the practice outside of institutes and of education and higher education. All right, with that, I will kick it back to Sharona.
Thank you. Thank you for all those terrific comments. Again, please type your questions into the Q&A at the bottom of your screen. And Ray, it looks like if we're going to have a Justice Amy Coney Barrett, we'll have another academic at least. So she taught at Notre Dame for, I think, a couple of decades. So I will start off just by the question that I think is on many minds, which is, what do you experts predict regarding the replacement of Justice Ginsburg? What do you think is going to happen? Jonathan Enton?
I'm not sure that I have sufficient detachment to give a coherent answer. I think it is a sign of the degraded state of political discourse that the Senate can't even agree on the terms of a resolution honoring Justice Ginsburg's memory, because both sides seem to want to load it up with partisan shots. So I don't really know where this is going, except I think it is pretty clear that whoever President Trump nominates is almost certainly going to be sold as a staunch conservative, and that person will be confirmed by a largely party line vote. But I think that we live in an era where essentially party line votes on Supreme Court nominations and lower court nominations raise fundamental questions about the notion of an independent judiciary and the whole concept of the rule of law. That's why I ended as pessimistically as I did. I hope we will get through this, but I think we are in a bad place, and if anything, it will get worse.
Okay, Jonathan Adler.
I'm not going to offer a prediction. I mean, apparently we will have a nominee this week. And will there be a vote? Will there not be a vote? I don't know. I agree with much of what Jonathan Hatton said, that Justice Ginsburg is the last or the next to last judge or justice to be confirmed in what was really a different era in terms of the way Supreme Court nominees were treated and considered. She was the last nominee to only have a single-digit number of votes against her. She was confirmed 97-3, and the time from her nomination to confirmation was something like 44 days. The average confirmation time since 1975 has been 70 days. So, I mean, she's on the much earlier end of that book, in large part because it was such a different era, and she, during her time on the court, repeatedly lamented the fact that the confirmation process was no longer like the process was when she went through it. Certainly when after Justice Scalia died and Garland was proposed, she made those comments, but she had made those comments earlier as well, that she felt that a process under which a president was presumed to be able to nominate a justice who would be confirmed provided they were qualified was a better way to go. And that's certainly not been the approach that many senators have adopted since, and increasingly that senators have adopted since, such that the last few nominations have been by party line votes or very close to party line votes.
Ray, do you have any comment?
But, I agree with John Etton. This could go very badly. And at the very least, I do think that whatever happens, the current state and customs and traditions of the court will be fundamentally changed. Whether it's going to be the pressure that's put on whether or not we will confirm a nomination in the next couple of months before the new president is sworn in, or what happens afterwards, right? Because there will be, to the extent there is a new appointment now before whether Trump gets reelected or if Biden wins the presidency, we will see a very strong effort on the part of the Democrats to reform the court in either the composition of the court, the numbers of justices on the court, or any other kinds of reforms along those lines. And I do want to agree with my colleagues that part of the lament over this process is now it's not just fundamentally political, because I would argue that political suggests that there's kind of a greater degree of discretion in the choices. One of the things that's happened is that we have, to quote Justice Scalia, essentially abandoned the view, or at least kind of hardened our view of what a lawyer's job is, right? So he once wrote in a dissent that, they pretty much leave us alone, right, when they think we're doing lawyers' work, right? We're reading the text, we're reading statutes, reading precedent. Many people, and quite accurately, don't believe that's what, at the very least, the justices do on the Supreme Court anymore. And so hence you get this essential partisan divide. But the other aspect in the justices' defense is we're in the 21st century. Many of the fundamental issues that we are debating today are truly issues that divide Americans based on fundamental principles. Now, some of these divisions have existed ever since the 18th century, but some of them have definitely calcified more over time, right? So we're not arguing about small questions anymore. We're arguing about big questions. And that is being played out in the political process right now. And frankly, it really is up to the Republicans, right? To what extent do they see pushing the nominee under these circumstances as worth it in terms of potentially losing the Congress in both bodies, including the Senate and the House, or if they think it may make more sense to kind of play the more traditional compromise game and recognize that the McConnell rule is a little bit of an odd rule and that maybe it's not being applied kind of objectively or fairly under these circumstances, right? And take that higher road. As John Enton said, I'm not optimistic about what's going to happen. And so it's very interesting times to live in.
Okay, well, Professor Hill, you can comment on that, but I also have a question specifically for you, which is, how do you think women in law school and young attorneys or even judges have been influenced by Ruth Bader Ginsburg? She inspires girls and teens today. Was that the case when you were in law school, and what are your reflections?
Absolutely, thank you. And yeah, I'm not sure I have anything much to add on the prior question, except that I have a hard time seeing any universe in which somebody doesn't get appointed, confirmed before the next president takes office. But yeah, absolutely. I mean, she is a huge inspiration. I think, I will say her star status, her sort of pop icon status has been much more recent, right? She didn't kind of have that notorious RBG thing going on when I was in law school. Certainly, actually, the VMI case, the one that we've mentioned a few times, which is really probably her most well-known opinion and one of her most important in the area of gender equality, came out like right before I started law school, right before I took constitutional law. So this issue was still very much live, right, in terms of women's access to all the places where men have been allowed to go for a very long time. And so I do think, at least for me personally, her history as an ACLU lawyer was something that really inspired me, and to see that you could actually change the world with litigation is something that kind of blew me away when I realized it in law school, and it helped shape my own career path to a large extent, and I think does account for some of the sort of popularity of that career path for people who want to make a difference, particularly in certain areas. But yeah, I think that the more recent, the extent to which I suspect there are going to be like RBG costumes at Halloween this year and so on is a much more recent thing. It's very cool to see, though, in my mind. I actually have you can't see them, but my earrings are RBG dissent collars that I'm wearing tonight. So
very appropriate. So we have a question about, does anybody have any predictions about whether the Democrats, if they win, will expand the court in response to an appointment that goes through now? Anybody?
I don't have a prediction on that, but I think it is a terrible idea. There's nothing in the Constitution that fixes the number of seats, but we've had a 9-justice court for more than 150 years, and that's been kind of a tradition. My concern is that if the Democrats win the White House and the Senate and keep the House, and they manage to push through an expansion of the court, first of all, if they're concerned about getting the quote right outcome, they're going to have to increase the size of the court by 4, not just 2, assuming that the new justice is appointed. But whatever the number is, 2 can play at that game. If the Democrats increase the size of the court when they're in control, then the Republicans, when they are in control, will do the same thing. And somewhere along the line, somebody is going to decide, we're going to try to increase the court by an enormous number, at which point the ability of the court to do its work will be called into question. And more to the point, the idea that we're going to change the size of the court because we don't like the current ideological composition of the court suggests basically that law is only politics. And I think that that is fundamentally destructive of the whole reason that we have law and courts. I'm not naive. Surely there are some political aspects to the law, but I think it would be a terrible mistake for us to decide that's all that's going on here.
If I could jump in, I can't, I'm going to say I can't disagree with Jonathan more vehemently on this issue. Maybe it's a generational thing. I remember, I believe it's an old Sean Connery quote about, it's like bringing a knife to a gunfight. Under these circumstances, I would have agreed with the much more traditional custom, following custom approach towards appointing justices. But essentially, the Republicans under Senator McConnell have already blown up that process. And if Democrats are going to say, well, we are going to rely and kind of, a la Michelle Obama, take the high road, they will essentially be kind of enabling a court that does not view itself as a fundamental body of legal principled reasoning. Just think about the judge that's being nominated or potentially considered, who was a professor at Notre Dame, right? The fundamental that the Bible and kind of can serve as more important principle than the Constitution and its founding, and that precedent doesn't matter under those circumstances, right? The fundamental rejection of precedent when the court has gotten it, in her opinion, wrong. And that's a problem, right? And so to the extent that we want to preserve a system of separation of powers, the Supreme Court is a fundamental element of that. And if it takes the Democrats to, essentially play and respond to the Republicans' game of hardball with hardball politics of their own, which I think they fundamentally must, then it leads to whatever consequences it leads to. So, one of the things that Professor Cass Sunstein argued years ago is that the Constitution and constitutional law can change not just by formal amendments or by necessarily Supreme Court's interpretations, but the changes in the political system and the election of representatives and the election of the president, right? So if we have the public saying, now it is time for the Democrats to control Congress and the presidency, and we know what the stakes are on the Supreme Court, it may very well be an important signal that in our system that, we shouldn't allow one party to essentially have taken at least one seat and then kind of arguably leverage that into two, right? And so, this is a fundamental thing that we need to respond to.
Any
As
other
folks might
reflection?
expect, I disagree with much of what Ray said. I'll just say first on Judge Barrett, if people want to know about her views, ignore a lot of the stuff that's being written and said, and watch and listen to the speech she gave here at Case Western last year. But the idea that her view is the Bible supersedes her oath as a jurist, I think is plainly belied by her performance on the bench, as well as by her writings, both as an academic, including the speech she gave here at the law school, and which was just published in the Case Western Law Review. In terms of what happens with the court, I think it's important for us to understand that the politics of judicial confirmations have been a game of escalating retaliation at this point for 35 years, in which each party has decided not merely to retaliate in kind to the offenses of the other party, but to do so and then some. It's kind of like two kids sitting in the backseat of a car during a road trip, where it's not enough to nudge the one next to you. If they nudge you, you got to hit them a little harder, and eventually someone starts striking real blows, and that's what's happened. But the idea that either party has not engaged in escalatory retaliation is simply false. And in fact, in earlier times, folks were very open and upfront about it. In the mid-1980s, when Senate Democrats decided they did not like the sorts of people that Ronald Reagan was appointing to the federal bench, and thought that this effect was untoward, even though Jimmy Carter at the time had a record number of lower court appointments in a single term for any president, a record that the current president is unaware that he has not matched despite his bombastic rhetoric to the contrary. They were very open about the fact that they were going to find ways of blocking nominees and in fact refused to fill seats pending elections with the hope that those seats could then be filled by a Democratic president. So Judith Hope was the pivotal seat on the DC circuit in 1988. She was never confirmed for that reason. Pam Reimer, the same thing. Democrats didn't win that election, so Pam Reimer got renominated. So we've forgotten her story, and we forgot Judith Hope's story because she was not renominated because she had supported Bob Dole. And to give another story that is probably fitting, given that we're talking about the legacy of Justice Ginsburg, Lillian Bevere, who was the first female full professor at the University of Virginia Law School, one of the most important female constitutional law professors, in fact, scratch female, one of the most important First Amendment scholars of her generation, was nominated to the U.S. Court of Appeals for the Fourth Circuit in October 1991 to a seat that was a newly created seat. So there was no dispute over this having been a seat that someone else didn't get to fill or whatever else. And she went 13 months without a hearing, let alone a vote or whatever else. And that action, the action that what was done to Hope and Reimer and others, is what Republicans clearly retaliated against when Bill Clinton became president. And then Democrats retaliated again against Republicans when it came to George Bush's nominees, including escalating the process by introducing the filibuster of lower court nominees for the first time in the nation's history. And Republicans then retaliated again to Obama's nominees. And at some point, folks need to recognize that escalating retaliation ultimately deprives the courts of what we want them to do, which is to be a check on the political branches. And if neither side is willing to engage in some sort of de-escalation, that is where we would end up. Last thing I would note, I think there is some hope from the court itself. There's at least one, if not more, justices on the court that believe trying to have the court recede from its role in public life and in political life is one way to lessen the stakes. And pursuant to that, it is worth noting that since John Roberts has been Chief Justice, the rate at which federal statutes have been struck down and the rate at which the court has overturned its prior precedents is lower than under any other post-war Chief Justice, and it's not even very close. So in terms of having the Supreme Court being less of a veto to the political branches, we've been moving in that direction. And hopefully if the political branches can't figure out how to de-escalate, that trend in the Supreme Court may help us save us from this mess a little bit.
If I can just add one quick question to John, given your very good factual recitation, how many Chief Justices of the Supreme Court have been appointed by the Democrats since the 1950s?
Successfully appointed?
Yes.
There haven't been any. The last effort was Abe Fortas, which was done in an election year because Earl Warren wanted to retire before the election because he did not think he could last another 4 years. And it was very controversial for a range of reasons. So Southern segregationists opposed him because he had supported civil rights. He was opposed in part because of ethical concerns, but he was also opposed by some Senate Republicans who were upset by the transparently political timing of it, especially because in 1960, the Senate, with the Democratic majority, had passed a resolution saying that we should try to avoid election year vacancies because they had been so upset by the election year vacancy in 1956 that Dwight Eisenhower had filled with the recess appointment of William Brennan. And even though William Brennan was a Democrat, it was understood that Dwight Eisenhower did that for political advantage by putting a Catholic, only the second Catholic ever in the history of the Supreme Court, on the court. And so up until 1968, Democrats had been firmly against the idea of a vacancy in an election year. And that was necessary for to push the votes against Fortas over the top. So it's been a problem. There's a reason why since 1968, the only times we've had election year vacancies have been due to tragic deaths, because justices have recognized it's something our political process doesn't handle very well. And we're seeing right now, it does not handle this very well.
Jesse, do you have any comment on any of that?
I mean, I just think that the question of who started it is less important at this point than questions around, what is the impact of continuing it? And, I think Ray has made a point that hasn't been really, but I probably disagree with Ray. I've been going back and forth about this myself over the past few days, and I think it's probably still a bad idea for all the reasons I have thought that all along, to pack the court. But I will say that Ray raises a point that hasn't been responded to, about the sort of very big disconnect between the composition of the Supreme Court right now and the sort of mainstream of the American people, and and the same thing being true of kind of the Senate as well, in terms of how our political institutions are not constructed to reflect popular will.
So I got
Let me
another
just throw
question.
two other things that I think will affect this going forward, that I think the Senate is actually more likely to consider. There's renewed conversation of jurisdiction stripping, of finding ways of constraining the ability of the courts to consider certain sorts of questions. And I would not be at all surprised to see discussions of that after the election. And in terms of finding ways of rebalancing the political process, I think it's far more likely that if we have a Democratic Senate and a Democratic president, that DC and Puerto Rico become states than they increase the size of the Supreme Court.
I agree with that.
So we just have a very few minutes left, but I got another question about the composition of the Supreme Court. And the questioner said there are 6 Catholic justices and 2 Jewish justices. And of course, Justice Ginsburg was Jewish and died on the eve of Rosh Hashanah, of the high holidays. So what's up with that? Do we, and the nominee now may well be another Catholic. Is that of significance? Are we going to have a Protestant justice at some point? Any comments on that?
Well, we have a Protestant justice now. That's Justice Gorsuch. There was a point at which I think there were no Protestant justices. My sense is that one reason that there are so many Catholic justices on the court is that some of the issues that are particularly salient to important segments of the Republican Party are issues where conservative Catholics may be viewed as more reliable than other folks. I don't have great insights on this, but I suspect that may have something to do with this. But I also am a little concerned that we're even getting bogged down in the religious composition of the court. I mean, there's a substantial part of the American population today that doesn't identify with any particular religious background. And, I mean, to paraphrase Roman Ruska back in the day when he was talking about Harold Carswell, aren't they entitled to representation themselves?
Anybody else have any thoughts?
I think when it comes to any of these sorts of characteristics, it might be worth remembering a comment that Ruth Bader Ginsburg made when asked about the proper number of female justices on the court. And her response was, why not 9? And I think, the aspiration should be that people are chosen to be justices because of what they bring to the court in terms of their experience, their capabilities, and their qualifications, and not these other characteristics. And so the fact that we may end up with 6 Catholics on the court if the president nominates and the Senate confirms another Catholic, I think that's less important than what we think about the individual justices. Justice Thomas and Justice Sotomayor are both Catholics. It's not as if they have similar approaches to the law as a result of that. So I think we should be focused more about this on the substance of their views and how they approach their jobs.
Okay, well, I got a question in the chat noting that I teach employment discrimination and health law, and was Justice Ginsburg important to those fields? What is her legacy? And of course, she is very, very important in both of those fields. She is a pioneer in terms of fighting discrimination, and gender discrimination is still a huge issue in employment discrimination. We talked about the Lilly Ledbetter case that had to do with equal pay. Of course, she dissented in that case, but eventually Congress passed a law that mandated, that changed the rules for bringing Equal Pay Act claims in ways that are very helpful to plaintiffs. In health law, Jessie talked about reproductive rights, and she was very important in those areas of litigation, though she didn't write majority opinions most of the time. But I think lawyers, especially female lawyers, have her as an icon and a hero, and will not soon forget her for everything that she contributed, both in the fields of employment discrimination and health law for women's rights. So I think we are pretty much out of time. We still have questions, but I don't think we have time to tackle them. So I just want to thank our fabulous speakers. This was thrown together in a couple of days, obviously, but it was really a great program, and I think everyone learned a lot, and we really appreciate the time you put into preparing for it on such short notice. And also thank you to everyone who attended. We had a terrific turnout, again, on very short notice, which is a credit to Justice Ginsburg, and really shows us how much people cared about her and will miss her, and what an impact she had on American jurisprudence. So thank you to everyone. Have a good evening, and we hope to see you soon at another Case Western program.